Hello, everyone. We have a hard stop at 3:15, so we're going to go ahead and get started. I'm sure people, as they get something to eat, they'll trickle in and they can join the conversation. My name is Andrea Schemberg. I was an advisor to John Ruggie in his mandate. I led his investment and human rights work. And I thank the working group and the OHCHR for inviting me to chair this, to moderate this panel. It's a panel that for me is incredibly important, and we are so lucky to have the panelists that we do today. What we've done to save time is we have, in the back of the room, you'll find their biographies so that we won't have long introductions, so that we can get right to the substance. And the subject for today's talk, and let me just say, as with other panels and discussions, we have a speakers list so that we can have some variety of questions. There's a woman in the back in blue, if you could just raise your hand. She's got the speakers list, so please put your name on it for speakers. And also, when you're formulating your questions, could you please direct your questions to individual panelists instead of the whole panel? As we have tight time, we'll give one panelist the opportunity to respond to those questions. The subject of today's meeting is the Principles for Responsible Contracts. This document is in the back of the room. And as Gerald said in the session on conflict, when John submitted his final report with the guiding principles, there was so much excitement and attention around the guiding principles that the other documents that were submitted as well maybe got lost in the mix a little bit. And one of them might be this document, which is the Principles for Responsible Contracts. And this document is a guide for negotiators, and it's a guide regarding the management of human rights risks in the context of big investment projects. So it's a quite specific document. And I'll just take 2 minutes to describe how we arrived at doing this, at creating this document. What this document is a collection of experience. A collection of experience, and it represents a consensus of sorts that was built up among practitioners over a period of 4 years of research and consultation. And what's the premise of this document? The premise of this document, as we heard John remind us yesterday, of global governance gaps. And early on in the mandate, he understood the relevance of investment to both identifying places where there are global governance gaps, but also specific places where you might take actions to try and bridge those gaps. So what we understood was that investment contracts were important. We did a research project that others may talk about on something called stabilization clauses and investment contracts. We were looking at specific clauses that are sometimes in investment contracts, trying to understand their relationship to the state duty to protect in particular. And then after years, really, of research and consultation, we arrived at the idea that it would be a good idea for the mandate to come out with something very specific and practical that relates to the world as it is. In an ideal world, you have a host state where you've got obligations to international law in place and that are implemented, constitution, policies, laws that are all in line and keep human rights safe and also bring sustainable development benefits from large investment projects. But we know that's not the case. The reality is often huge investment projects or investment projects that have a large potential to create opportunities or risks for human rights, often they take place in countries where we don't have the policies and laws and implementation and administrative capacity to keep people safe and to actually reap the benefits. So this document was written in thinking about reality in John Ruggie's Principled Pragmatism. This is not also a document about fixing the world through contracts. Nobody pretends that contracts is the key to the panacea for all of our business and human rights problems. It definitely is not. It is one small contribution that contributes to a cumulative impact over time, and with all kinds of other things happening. So just with that, what I'd like to do is, how the panel will be organized is, we've got 4 themes we're going to talk about. We're going to talk about why some of the panelists' organizations were involved in this project, what motivated them. We're going to talk about obstacles to integrating human rights risk management into these projects. We're going to talk about how the principles might be useful. And then we're going to talk about momentum and trends. What openings are there? What opportunities are there to improve the management of human rights risks in these large projects? We have an incredibly distinguished panel with a varied set of experiences and perspectives. I'll do a short introduction to them as they respond to the first question, but please add to your own description, your biography, if you feel that it's interesting for and relevant for what you're about to say. So the first set of questions is about, because we have a few of the panelists that were directly involved in actually consulting and creating this document, Principles for Responsible Contracts, I would like some description of what motivated you or your organization's involvement in this project. So why was it deemed important for you to feed into? In other words, how might this document relate to your context, your work, your organization? And to kick off, I'd like to ask Motoko, who is from the World Bank now. When she was involved in this project, she was at the IFC. But Motoko, can you tell me, as principal author of the 2006 IFC Sustainability Policy and Performance Standards, and now as in your involvement in the World Bank and what you know from that context, why were you motivated to be involved in this project?
Thank you, Andrea. Good afternoon, everybody. First of all, thank you for the invitation to be on this panel. This topic is very important for me personally. And so let me start from the beginning, once upon a time. In 2003, when BP was involved in the BTC, Baku-Tbilisi-Ceyhan pipeline project, they came under a lot of pressure from civil society organizations and ended up disclosing their host government agreement, a very unusual move. And Amnesty International analyzed the contract and realized that there is this very massive stabilization clause which tied the hands of governments prevented them possibly from implementing new laws that might support environmental and social issues in the future. IFC was a financier of that project, and so we watched the debate unfold with fascination. And when John Ruggie took up the mandate and started to look into a lot of different issues, including business relationships and contracts, this topic of stabilization came to his attention. So he came knocking on the door of IFC. He said, IFC, you do a lot of investment financing. So what about the stabilization clause issue? Is it an issue or isn't it? Is it a red herring or isn't it? That was the exam question that was on the table. There were several lawyers from IFC who felt that the type of stabilization clauses that the NGO talked about were pretty much out of date. Nobody really used it. Nobody really used freezing clauses anymore. Economic equilibrium clauses, perhaps to some extent. But we needed to know, and as a result, Andrea and I worked on this stabilization clause paper, which is on IFC's website. If you type IFC sustainability and stabilization, you will get this paper. To my surprise, and perhaps to yours too, Andrea, we did find a huge variation, whether the contracts were from OECD or not, and variation within different sectors. So mining sector and Africa tended to use more wide scope stabilization clauses than others. Now, I think there's a reason why. It's probably correlated to perceived risks and risks of changes of law in certain jurisdictions. So perhaps there's no wonder about that, but there is actually quite a significant variance in this practice. And so this report was a contribution to the Ruggie mandate from IFC. And we followed the progress of this discussion throughout the mandate and participated in various brainstormings to figure out what kinds of things, tools, principles, guidelines, etc., that might be helpful to practitioners. And the result is the responsible contracts principles. I think they are very useful in that if one approached contracts from a host government agreements and concession contracts and whatnot from a business as usual attitude, whether from the business side or the legal side, the issues that are treated in the principles are not necessarily something that you would think about first and foremost. So I think they're very useful principles for negotiators and others who deal with contracts and the contracting process. And here I mean from the beginning all the way to implementation and monitoring and reporting and including civil society monitoring. So let me stop there, Andrea, and perhaps I have another chance to come back at it. Thanks.
And now I'd like to hear from Antonio Carvalho Quello from Total. Total was involved in the consultations. They offered a lot of time and thought to this process. So I'm curious, why would a big oil company be involved in such a project, and why you personally would you give your time?
I will give you my personal impression and approach. First of all, I'm an in-house lawyer in the legal department of the oil and gas division of Total. Total is a big French oil company working in the energy sector. It is present in conducting activities in around 130 countries in the world. And I'm here really as a very traditional commercial lawyer, working on traditional legal issues. I have some experience on negotiating and drafting contracts with states, with state-owned companies, with other oil and gas companies to form joint ventures, to contract with suppliers of goods and services that are necessary to conduct our activities. So I'm not a specialist at all of sustainable development or human rights issues. And when my colleagues that have experience on these areas invited me to discuss around the United Nations guiding principles, on the principles on responsible contracts, I must confess that my reaction was not very positive. I told them, we have already health, safety, environment, due diligence process, very complicated. We have, for the same areas, we have very detailed clauses. With respect to the prevention of corruption, we have also a specific due diligence with specific sophisticated clauses. We have clauses on the hiring and training of local people, on hiring of local contractors. And now you want us to add an additional layer of rules. Our contracts are already so big, dense, complex, and you want us to aggravate this. This was my first reaction, sincerely. Then my colleagues, some of them are present in this room, explained to me that health, safety, environment are already issues related to human rights. They also told me that environment impact assessment today should be viewed in connection with social impact assessments. Another explanation, they told me human rights at work may be a problem, a real concern in many countries, especially with respect to our suppliers. Of course, the problematic question of the personal security, physical security, and the risk of being accused of complicity for human rights abuses related to the security forces. So, at the end of the day, they convinced me, and I recognize that it's really pertinent to think about changing our contractual philosophy practice to improve our due diligence process, to improve our standard contract. So I changed my mind, but I believe that there is some room for progress. I believe that I have some doubts even about some aspects, including stabilization. We can come on this issue. But I'm here, and I'm very glad being here in Geneva in this forum to learn about good practices and other exchange experience on this field. Thank you.
Thank you. Thank you. And now let's hear from Herbert McLeod, who is currently the Special Advisor in the Office of the President of Sierra Leone. In this position, he provides advice on economic development issues with a focus on mining and finance. Why, Herbert, when we invited you to an expert meeting and engaged you in this project, were you willing?
Thank you. In 2007, there was a new government in my country. In 2008, they announced that we should look at all existing, at the operations of extractives, mining. And I was asked to lead a task force on this. With some support from externals, some of the law firms, but also from people like Lou Wells from Harvard and Revenue Watch, we went through and we quickly saw that the situation was really abysmal. Beyond what normally people say, which is, when I say normally people say, I mean in my country, people talk about the company is going away with everything and we are getting nothing. Beyond that, there are lots of issues that go beyond just having a right contract. When we also looked at the literature existing at the time, the prescriptions did not seem to take into account effectively why states in conflict situations, and interestingly, I should have mentioned that I was UN resident coordinator in the DRC for UNDP for a while. Why it is that these states do not behave in what would normally be considered a logical way. And so when the opportunity came to participate in what Rugi was doing, I saw this as an opportunity to learn more about what is going on in, especially, for example, stabilization in non-conflict situations where the risk is supposed to be less high, but in Africa you find some strong stabilization clauses even in those countries, and how one could deal with that. But more importantly, how to deal with the weaknesses that are peculiar to conflict-prone countries. And I'm referring here not just to situations where you have the conflict taking place, but where we are sort of, so to speak, post-conflict, and where you have these challenges that prevent the right decisions to be made, the right actions to be taken. And for me, this was an opportunity also to bring international community, draw the attention of the international community to put possible support that they can provide to such states.
And finally, from Lorenzo, who's the senior researcher in law and sustainable development and the team leader for investment of the International Institute for Environment and Development. Lorenzo, why did you view this project as something worthy of your and your organization's time?
Thank you, Andrea, and thank you very much for involving me in this panel. It's a real pleasure to be here. Well, I should say for a start that IIED's mission is to promote sustainable development. We see a very strong degree of overlap, complementarity, mutual reinforcement between sustainable development and human rights. And for us, the starting point of our work on investment is that for host countries and communities, promoting investment is not an end in itself, but is a means to an end. And that end, presumably, is to improve local lives. And so if one looks at it that way, then the quality of the investment is critical. The quality is to be assessed not so much on the basis of sort of corporate philanthropy at the fringes, but on the basis of the core business model. And contracts are very much a key element of that. They very much define the way in which risks, costs and benefits involved in an investment are shared between multiple parties. So for us, this was an excellent opportunity to engage on an issue that we deem particularly critical. I had the pleasure to meet Andrea, I think, back in 2004, soon after Amnesty International published a report, the report that Motoko mentioned, that really kick-started much of this debate. And I think if we look back, the discussion then, to think that there would be a UN document like the one we have now, we might have thought we were daydreaming, and so the opportunity to have an authoritative recognition that there is an issue, that contracts and human rights are related, and also to have authoritative guidance on how to deal with these issues in an actual negotiation for us is a very valuable thing that has happened through the John Ruggie mandate. I would like to add that the principles target, in terms of audience, negotiators on the government and the private sector side. Civil society is not a target audience, but nevertheless, I believe that the document is of extremely useful for civil society. There's been, over the past few years, really growing engagement, growing scrutiny on the part of civil society, not only in terms of the activity of business and their human rights implications, not only in terms of investment, but particularly with regards to investment contracts. Looking at what the contracts say, is the country getting a good deal not only in terms of the economics, the fiscal regime, etc., but also in relation to the extent to which human rights considerations are taken on board. And that interest perhaps originated from organizations based in the north, but I see that there's now growing engagement from organizations that are based in the countries where the investments take place. Earlier this year, an organization from Cameroon called Center for Environment and Development, they published a report where they scrutinized one big contract for a large palm oil plantation, really went through clause by clause to say what are the implications of this contract for the livelihoods of people affected by it. And I think that's a very important step forward, and I believe that the principles provide very useful guidance for people engaged with this work in terms of what are the issues that we need to look out for, what are how far can we push the boundaries, what are the questions we need to ask, both on the government and investor side.
I failed to say earlier that one of the panelists, unfortunately, Councillor Seward Cooper, who is the legal advisor to the president of Liberia, who was supposed to be here, he unfortunately was sent to Washington. So he wasn't able to be here, but he did give me written comments. So if you'll forgive me for reading, he did want to respond to this question in terms of what motivated his country, because Liberia was also involved in the consultations, in feeding in and looking at drafts of this project. So they were very involved. And Councillor Cooper says, Liberia, as a developing nation and post-conflict country, has realized its potential of entering into investment contracts. It's important that it prepares itself for legislating, regulating, and negotiating with the aim of protecting its citizens. Liberia's President Ellen Johnson Sirleaf emphasizes economic development and strongly advocates human rights principles, especially those enshrined in Liberia's constitution and laws, including international treaties that the country has ratified. This project provides an insight on negotiating and legislating investment agreements in a way that safeguards the fundamental human rights of our people. So I thank him for that. But let's go on to now looking at the reality. So we've heard about this project, we've heard about the document, but there's a reality on the ground, and the reality is that generally in negotiations, human rights are not subject of concern. They're not seen as core business. And let's talk for a minute from the experience of the panelists about the obstacles to integrating human rights risk management right up front in the projects and at the point of negotiating. And just as a reminder, these principles don't dictate what should be in the contracts, but say at the time of contracting, the roles and responsibilities for certain issues, such as physical security, such as who's going to deal with community engagement, how is that going to be organized, those issues have to be dealt with up front. So let's do an exploration of those obstacles, and I'd like to ask Benoit Palmer, who's from Rio Tinto. He's the lead legal counselor for the Simandou project in Guinea. If you can talk a little bit about what are the obstacles to integrating human rights risk management up front in these projects.
Hello, everyone. My name is Ben Palmer. I'm an in-house lawyer for Rio Tinto. I have been for about 10 years now. And during that time, I've been lucky enough to work on a couple of very large development projects in Africa. Right now, I'm working for, I'm the project lawyer on the Simandou project, which is a large iron ore project in Guinea, which is in West Africa. Just before going on to the obstacles, I just wanted to add that Rio Tinto, I think, was involved, did provide some comments on the principles. And Rio Tinto does obviously support the UN guiding principles. We're committed to incorporating social and environmental issues and how to manage those and human rights issues into all parts of our business. And that includes in projects. In projects, Simandou, for example, I'm thinking of the social and environmental impact assessments, the resettlement and compensation programs to acquire lands, which follow the IFC standards. As Antonio was mentioning, in terms of employment strategies, by local programs, local training. So these types of issues are really part of our core values, and it's something that we do try to integrate into all aspects of our business. In terms of your question, Andrea, obstacles, I have worked in at least 2 negotiations for investment agreements. And I mean, one obstacle that seems to come up immediately is just just that there can be a lack of awareness of the importance of things like social issues and environmental issues, and that includes obviously human rights. To the importance of those issues to the success of a project, and I think those issues really need to be understood to be important project parameters that need to go into investment agreements, just like other parameters such as the economics. And in my experience, at least, the negotiating teams for investment agreements have been quite small, and usually there are 3, 4, or 5 people involved on the company's side, and really they're commercial negotiators, people with financial backgrounds, people with legal backgrounds. They don't necessarily have all the peripheral expertise needed, so they have to draw upon information from tax people. They need to draw upon technical expertise from within the organization. Again, in my experience, the reflex to go get input from people who have human rights knowledge has not been an automatic reflex. I think that has changed over the years, but I think it's more and more important for negotiating teams to draw on that experience, whether it's internal or external. The second obstacle is really just a kind of a meeting of the minds between governments and companies as to an agreement that these types of issues really should go into the investment agreements. And I mean, it might seem straightforward, but there are always certain sensitivities that can arise. And I think on both government side and company side, for companies, it's how do you raise the issue of introducing human rights into an agreement in a way that doesn't somehow imply that, human rights are not being respected by the government. Governments might have a view as to whether they should push human rights in investment agreements, or would that somehow jeopardize, the transaction from actually getting done. So those types of issues as well. Sorry, just a last obstacle in terms of costs. I think some people equate increasing project standards with increasing costs to a project. I think generally that's probably true, but in terms of human rights, at least the view of Rio Tinto is it's a given. You need to respect those types of things to establish and maintain your license to operate in the country and with the communities. And basically, it just needs to be a given. It needs to be paid, whatever that cost is. In any case, the cost of not respecting human rights is just unacceptable.
Thank you. And I think your comments bring up Principle 1. When we wrote the document, we said no negotiator is going to deal with human rights issues unless they're tasked to do it. So in Principle 1, we talk about actually in their negotiating objectives, this has to be part of their job. And I think it reflects the reality that it's usually not. And I also, with respect to what you say in terms of sensitivities, one of the hopes that we had with this document is that this was a neutral ground. This was a neutral organization, the UN, coming and saying these are the kinds of issues that should be thought about, and so that it would be more non-threatening. Of course, it's always going to be a sensitive issue, but could this facilitate at least introducing conversations that maybe are a bit tough in reality? And now I'd like to hear from Herbert from the state side. What are some of the main obstacles you see?
Well, let's face it, the HR phrase, the moment you talk about human rights in a post-conflict or a third world country, it evokes all kinds of issues about sovereignty and an attempt to influence the politics and so on. So from my perspective, we use, by the way, the guide is excellent. I use the guide for resolving internal tensions, but definitely not under the rubric of human rights. The moment I do that, they say, here he goes again. He's very academic. He's here to push some Western neoliberal ideas. Forget human rights, just get to the issues, and everybody is ready to engage. But let me respond directly to the question, what are the challenges that we face? And I'm referring, again, I apologize, but I'm focusing on the so-called post-conflict situations. I'm not referring to the active conflict as in DRC, even though some of the challenges are similar. But in the situation of let's take the case of Sierra Leone, there was a decision to reform the sector. The decision was easy. Now, the implementation was very, very difficult because of weak institutions, poor capacity, and so on. You know all of that characterize the post-conflict environment. In addition, there is also tremendous pressure to resume economic activity. So the closer the time is from the peace process, the worse the agreements are. Because in my case, for example, a rather bad agreement is justified publicly by saying, look, there were no jobs in this area. At least now there are jobs. And you're telling me that I should not have X, Y, and Z because, you see? So there are these pressures to resume economic activity, to provide jobs, to be seen, because governments have very limited mandates, and therefore they tend to be very short-sighted in the way in which they make decisions. So the longer that you take negotiating an agreement, the greater pressure you get, asking what is going on, why is this long delay, what is the problem? If it is just this minor issue of, I don't know what, the environmental impact not being ready, why can't we give them a temporary one until it is ready so that we can get on with economic activity? These are the kinds of challenges that we face. In Sierra Leone, we are now at a crossroads. We could either make it or we could go down. And I am worried, for example, because of this short-sightedness that emanates from very short periods of a political mandate. Governments tend to prefer to take decisions that would provide short-term gains, even though it may well be at the expense of longer-term sustainable development issues. Let me perhaps stop here, and maybe I can come back later.
I actually had a follow-up question for you, and when you talk about this short-term pressure, is that internal? Are there also external pressures from other? Does the international community? What kind of influence do they have on this?
I'm glad you asked this question, because when one talks about the international community, it's very interesting. The people who go to the General Assembly are usually people from the foreign ministries. The people who support industries are usually from Department of Commerce and so on, and they don't speak the same language, even if they may have telephone contacts. I'm not sure they do. So what happens, by the way, this of course is more pronounced in a third world country than in the first world, but I see it all the time. Decisions are taken by certain groups that are not reflected in the way in which they behave. And the most striking one is when you have a development agency in a country and you have an embassy. The embassy is there to support the interests of the country. The development agency is there to promote development in that country. These two things are not always synchronized. And it's so interesting for us to see, for example, recently, our Minister of Mines, following a recommendation from a national conference, announced a moratorium. And this conference was supported by the development agency from that country, country X, okay? The ambassador comes in and says, I understand there is this moratorium and it's affecting our interests. What's going on here? So you see, we do need the international community. In the last session, they mentioned a coalition of support of home states that's supporting the DRC, or that's looking at the DRC situation. I'm not sure how effective it is, but as I said, logically it seems extremely valuable. And if we could have that kind of support as well, so that from the external you have one voice that is bearing on the host country.
Thank you. Thank you for that. Let's now hear from Hafiz Mirza, who we're delighted to have. He is the chief, I'm going to get the title wrong, but it's the chief of the investment issues section of UNCTAD. He has been extremely involved in very important work that UNCTAD is doing. If you haven't seen the World Investment Report, I think there are some copies in the back, or you have some. World Investment Report 2012. It's an extremely important document from UNCTAD. I think it represents something of a renewed approach on investment, and I would like to ask you, what are some of the obstacles that you've seen in your work for developing countries in particular for integrating upfront in development policy the issues around human rights and even sustainable development?
Thank you, Andrea. I'm very delighted to be actually on this panel. Excuse me. Before I start, let me just say one or two words about another reason why this topic is important. And that's because since about the year 2000, there's been a huge upsurge of investment in agriculture, more recently, infrastructure, which we have, of course, very large-scale contracts, and extractive industries, mining, oil, and so on. So there's been a huge increase. In fact, from our work, until the early 2000s, we thought that investment, especially by foreign companies in these areas, was actually a dying breed. And suddenly things have changed around quite dramatically. That, I think, is an important point to bear in mind. And partly because of this, we have had a series of reports, I waved one just now, on agriculture, infrastructure, extractive industries, to try to understand this from an analytical, economic point of view, and within that, of course, the context for the legal discussions we're having at the moment. So that's the first point to make. So what I'm doing is prefacing what I will say by saying that actually it's based on some research on a number of different industries, which we think is of relevance just on this topic. If I widen the issue into obstacles, hurdles, issues that one has to consider, difficulties, there are a whole range of these, but let me just mention three sets, and then, of course, we can discuss more later on. The first is simply to say that actually, until very recently, there was an ideological bent which tended to put much more concern on getting the investment into the country, right? That was very, very important. And as a consequence of this, a very wide range of international investment agreements were concluded, especially bilateral investment treaties, which means that whatever we do, and of course this particular document is a starting point, whatever we do in terms of negotiating contracts, those have to be aware of what that wider context actually is in terms of what is actually permissible at the moment. And indeed, when we were discussing the National Policy Framework for Sustainable Development last year, 2012, that was one of the biggest issues that actually we see as a hurdle to implementing, of course, our principles, but also very much these negotiating principles that you're outlining here. So that's the first set of issues I want to mention. The second set of issues, I think, is to do with the nature of states, investors, and contracts, those things taken together. We've already discussed, I think, has been already mentioned, the issue of capabilities of both states and investors. And of course, more is known about the capabilities of governments, which are often very dire compared to especially investors. I've seen in all of this work we're doing a whole range of very poor contracts, and I mean really poor contracts. So that is a very, very big issue that we can discuss negotiating, but how do we create a mechanism to ensure that those negotiations can be done in an effective way from the point of view of all parties concerned, but certainly from the point of view of governments and from the point of view of local communities. That's where the HR thing is very important. Having said that, it's not only about governments, it's not only about communities, it's also about the investors. We need to understand a bit about the type, the size, the experience of investors. We all know RTZ, we all know Total, major investors, we know what they do. Again, I've seen a lot of contracts which have been concluded with investors which are X, Y, Z. Nobody's heard of them. And one of the biggest concerns I have is actually a government which has been offered a deal with regard to a very major project will go ahead and actually create and sign a contract without even asking anybody who were the guys we're actually dealing with. And actually, it's a big concern. Actually, there are a lot of people out there. I'm not saying all of them are dubious, but there are plenty of investors out there who are not actually that well known, or more importantly, they may well have the right intent, but they do not have the experience to follow through on the contract which is actually concluded. So that, I think, is a big issue to be concerned about. Another thing is that we talk about contracts as if they're a singular thing, and of course, IT said and Total will tell me, actually, no, this is not the case. But when it comes to infrastructure, agriculture, extractive industries, in terms of the type of investment, broadly find that actually occurs, you have a whole range of different modalities. You have, of course, foreign direct investment where you set up an affiliate. You have build, operate, transfer type of contracts with a whole variety of different forms. You have management contracts. There are a lot of different types of contracts that actually one has to consider. So the danger is, of course, we have this lovely UN document. We think, hey, this is what we do. But actually, the devil is always in the detail, and understanding the form of the contract and how you have to think differently about human rights issues vis-a-vis that each of those contracts is actually very important. So that's a big difficulty, I think, that we have to get across to negotiating parties, especially governments and people in developing countries. The other thing is that, and I mentioned this to you before, Andrea, that we're talking here about contracts between states and investors. And certainly at a very early stage of development, you can see that this is the primary form of contract, especially when it comes to these sort of industries. But over time, as economies evolve, the state's role reduces. So I think we need to be thinking in terms of the future of actually contracts, which are not between states and investors, between investors and investors, or B2B type of contracts. And you already see that, for example, in agriculture. A lot of the discussions that we've seen have been about the state's role in agriculture, but actually quite often the key contract is not between the state and the investor, but is actually between, for example, investors and farmers who are contracted by those investors. And that's an element that I think we have to bear in mind. Actually, the parties may not be different, may well be different compared to what we're thinking about in terms of this document. So that's about the nature of the states and so on. And third and the final point, given time that I want to mention, is really I think we have to look at context and specify the objectives properly. What actually is the ultimate objective that we have in mind when we say, look, in our negotiations, these different elements must be taken into account? Is it sustainable development, which is a longer-term goal, or is it maintaining the status quo? Those are not the same thing. You may well be respecting the rights of people today, but are you respecting the rights of people in the future? So there is a huge intergenerational issue here, which is often not taken on board in these contracts. Because if you're an investor, of course you want to get that deal. You will negotiate something which actually makes sense today, but you are not necessarily thinking of the future. It's up to other actors to actually think about the future, and of course, ideally, the company as well. So there is an intergenerational issue. There is an issue of what are the ultimate objectives. Sometimes we get hung up on human rights issues in terms of how we interpret them. Food security is very, very important indeed. But actually, again, if you try to maintain food security by saying, look, let's make sure that, for example, this particular smallholder is not in any way affected by this contract, what you are missing is the fact that actually today, as the world increasingly urbanizes, you are missing the food security of that urban population. So there are issues there that actually, in terms of upholding what you see as human rights of an individual or a farmer or a group, you're actually missing that bigger picture. So human rights are not to be interpreted as an absolute. They actually have to be understood in terms of that longer term and that wider context as well. I think that's a big issue that actually we find in a lot of our work, and I'm sure that will come up in terms of what we're discussing here as well. So basically, I think this document is excellent. It is certainly the basis for considering the negotiation of contracts. But in terms of getting the right outcome, there are a lot of other issues that have to be discussed and analysed as well.